Hi, if you or your children are suffering because of your relationship with your ex-partner, because it's stressed or strained, or maybe they're just not a nice person, this show is for you. Welcome to the High Conflict Co-Parenting Podcast with Brook and Charlie Jewett. Enjoy another episode now.
Welcome back, everybody, to the High Conflict Co-Parenting Podcast with Brook. This week's guest is Attorney Kelly Blackburn. And we're going to discuss restraining orders this week. And what we want to really do, I think, here, Kelly, is dip it a little bit, explain these restraining orders in a way that people can grok what they are good for, what they are not good for, the upside of getting them, the downside of getting them, when we have stuff coming in that is wrapped around false allegations. This is obviously a way to weaponize. I want to talk a little bit about that. And when it's being weaponized, how to come back and set the table straight, if you will, for these judges. So I'm going to just step back here for a minute, let you take an entry on that and tell me what you think about it.
Of course. Okay, Brooke. So I want to talk a little bit about domestic violence restraining orders. There are a multitude of restraining orders that somebody could potentially pursue. But when you're talking about parents or somebody who has an intimate relationship, they share a child together, you know, they're roommates that used to be in a dating relationship, or they were formerly married. That's where you're talking about a domestic violence restraining order. And the reason that I make the distinction, obviously, is I think for your listeners and your viewers particularly, as well as in my practice, domestic violence restraining orders really fall in the family court arena. And so I think it's most applicable here. However, the other reason I mention it is because there's a different burden of proof depending on the restraining order that you're pursuing. So as we go through this, I'm going to talk particularly about domestic violence restraining orders. If you want to talk more later at the end about, you know, workplace violence restraining orders or civil harassment restraining orders and what you would get those for or what they're good for, how you would use them, and whether or not it would be a good idea to prosecute claims on those, we can absolutely do that. I'm happy to answer those types of questions. With respect to domestic violence restraining orders, the burden of proof is very minimal. So first, now I'm going to make another distinguishing remark. There's a temporary domestic violence restraining order, or a TRO, and then there's a permanent domestic violence restraining order, a DVRO. And the reason that I make this distinction is because when you go to court to get a temporary restraining order, you just have to plead very minimal facts, sufficient to show that there's a likely harm that's going to be done, that there's some imminent threat to you, that you're scared. It's a very low burden. The way that the court reviews these or grants them is they do it in chambers, and they look at them, they read the application, they review the evidence, and they deny them or they grant them on the spot. Typically, you get them back the same day. There is a family code that tells you that if you file it before 3 o'clock that day, the court will process it that day. So you'll have that same day restraining order. In that restraining order, you potentially can have child custody orders. You can potentially get a move-out order. You can potentially ask the court for other forms of relief, financial relief, property control, somebody not to cancel a cell phone line, somebody not to manipulate a cell phone line. That's all within just the application of a temporary restraining order, which the burden of proof to get that, or the standard in the law to get that, is very, very low. Now, when we talk about the actual DVRO and prosecuting the merits of a DVRO requires a showing, and it requires a showing of evidence of its propensity. And so we refer to it in kind of layman's terms as 51%. Is it 51% probable that the things that you have stated are true, that there's been a harm, that you've been the victim of domestic violence? If you are, that's your burden of proof. You've now met your burden of proof, and the court can substantiate a finding of domestic violence, and they can grant they can grant a restraining order. And so it takes the temporary restraining order and turns it into a full domestic violence permanent restraining order. And that's the DVRO. And so now that we kind of have a foundation of where how you get there and how you apply for it, I want to talk a little bit about kind of the custody orders, the timelines, and just kind of what people need to know if they're applying for these. So if you apply for a temporary restraining order, the court has to grant you a hearing within 21 days. Why is that? It's because your liberty interests are restricted. If you are the restrained party in a temporary restraining order, your liberty interests are now impacted. Maybe you don't have custody of your kids. You can't call people. You can't contact people. You can't go to certain locations. Your freedom of speech is restricted. Your freedom of mobility is restricted. So you have constitutional rights that are being infringed upon by that restraining order. Now, there's obviously public policy behind it because domestic violence is so serious and the court takes it so seriously that they need that temporary restraining order to be able to be granted on the spot if need be. And your liberty interests, frankly, kind of take a backseat when they look at the risk-benefit analysis. In other words, the risk-benefit here is if you're applying for a restraining order because you're scared and somebody's putting you in imminent harm, the problem that you have if you're a judicial officer evaluating that claim is if it's even possible that that's happening, they need to grant you some sort of protection. And that protection, that benefit outweighs whatever risk or liberty interest infringement that's going to be put on the restrained party. And so that applies.
That's where the standard is really low to be able to get that TRW.
It's super low.
Okay.
So
the other piece along that, I want to come back real quick, but one of the things that I see from my standpoint, you and I do a lot of work together. So somebody can also extend that 21 days. There's places where that gets pushed out and that becomes problematic as well.
Correct.
What are the things that allow somebody to be able to do that?
So with respects to a temporary restraining order, if you are the restrained party, your liberty interests are the ones that are at play here. And so if you show up on that 21-day hearing and you say, Your Honor, I need an attorney. This is very serious. There's lots of implications. I need a continuance. The court has to, as a matter of course, has to grant you that continuance. You can never be pushed forward at that first appearance. The court, by matter of statute, has to give you that continuance if you're the restrained party. If you're the protected party. So the analogy here would be like if you were being charged with a criminal offense and you have a right to a speedy trial and the court says, well, do you want to just try to resolve this with the prosecution? And in the meantime, you can waive your rights to a speedy trial. That's the analogy. And so as the restrained party, you can essentially waive your rights to quote unquote that speedy trial, that due process provision that would otherwise require them to prosecute that hearing sooner than later. So that's one way. Another way is the protected party could potentially show up and have a lot of witnesses. And unfortunately, due to the impact of the court's calendar, they front load the TROs. So they have a lot of TROs on any given morning. There's a lot of TROs. And if you're not set for what we call in San Diego as a special set, but I know it's referred to as other things, other courthouses refer to it as a long cause. They refer to it as a trial. They refer to it as an evidentiary hearing. These are all kind of the same words that mean kind of the same thing. And if you're not set for a special set, the court might not have time to hear all of the testimony that the petitioner wants to put on. And so you may end up stuck in kind of a continuance by way of default. Now, what you want to do if you're the restrained party specifically, and you think that the other party is essentially playing games with the calendar, trying to keep it in play as long as possible, and we'll talk about the reasons why people would do that. But what you would want to do is you would want to do two things. One, you would want to ask the petitioner right away under Family Code 217, what are their witnesses that they're going to be calling. What's the witnesses that you have at trial? Give me an offer of proof. Because if they're not precipient witnesses, if they're all hearsay witnesses, or if they're all character witnesses that are talking about this domestic violence, it's potentially going to be barred by the evidence code anyway. So let's first pass the threshold of, do you even have testimony that you need to put on that's actually admissible and going to come into this trial? The second threshold is, okay, are you going to ask for an evidentiary hearing? In other words, if you are the restrained party, unless you're benefiting some way or another from the continuance, and there are a lot of reasons to benefit, but if you are not benefiting from that continuance, then you need to ask right away of the protected party. If they're asking for the continuance or asking you to agree to it, you need to ask right away whether or not they're going to ask for a long cause or an evidentiary hearing or some sort of future date. And the reason for that is because you potentially put yourself in a position where if you agree on the first appearance to a continuance, you've now waived time. You show up at the next hearing, you're still set for a short hearing. It's only a 20-minute calendar. The protected party shows up with, their mom, their sister, their brother, their aunt and uncle, and 75 other people you haven't seen in 7 years and don't know anything about your case. But they say, Your Honor, all these people need to testify. And now you're talking about a 3-day trial, and you're not getting to trial until 6 months out. And mind you, all the while, let's talk about the impact. The TRO more than likely remains in effect. Most of the orders on the TRO remain in effect. So if you got a kick-out order on your TRO, if you were asked to move out of your house pursuant to that TRO, that stays in effect. And so your former spouse or former partner or person that you had an intimate relationship with, the protected party in this case, they just get to stay in that house. There's, the custody orders potentially stay in play. And that's the biggest thing. And we'll talk about how DVTROs and DVROs impact custody specifically, but I want to get through kind of the procedural game playing first. So kind of what you need to know off the bat is if anybody is ever asking for a continuance, or if there's going to be a second date after that appearance and you're the restrained party, you need to go ask, well, what's your time estimate? How long is this going to take? And make them make a commitment to the court, because the court more often than not will take a commitment and say, no, counsel, you told me it was 2 hours, or petitioner, ma'am, sir, you told me it was 2 hours. We set it for 2 hours. And so you really have to kind of be very strong and pigeonhole them into what commitment for time estimate. Otherwise, you end up or could end up in this procedural gameplay. Now, with respects to kind of the temporary custody orders, some judicial officers are much better about it than others. But most of them, I think, operate on a base level of if they're still looking at the lens of child custody as best interests of the child. And so if you have a TRO, let's say that party one gets a TRO against party two, and party one alleges that, the children also need to be protected, and there's 2 children. Now, when you get to that first hearing as the restrained party, you can ask for, if there's no custody orders pled on the TRO, which more often than not, there's not, you can ask for temporary custody orders. Your Honor, in the meantime, your first request as a restrained party is, this has nothing to do with the kids, take them off. That's your first strategy. A lot of times that's denied. Your second strategy is, Your Honor, this is, the kids are not a risk. Give me at least some custody, because again, the lens that's best interest of the kid is not to have you as their parent just completely removed from their life for the next 6 months while this litigation is pending. And so you ask for some sort of interim visitation. It is critical that if you're learning about this for the first time, you rewind and listen to it again. And here's why: because this is going to be your only opportunity pending trial to get some sort of interim custody orders in place. And when I say only is a very strong word, but let's say no facts change. There's not, party one got a DUI, party one is being investigated for child abuse. There's nothing outlandish going on. Everything remains status quo. You don't have some big thing that you can ride home on in the next party. If you don't, then this is going to be your one and only opportunity pending that next hearing to really get the court to give you some sort of relief in terms of child custody.
That's a really important piece.
It's very important. And then the other factor here is if you're the restrained party, you don't want to go push through a custody motion as the restrained party, because Family Court Services is going to issue a report that says, well, you're the restrained party and we're going to let that work itself out. But pending that, let's have some supervised visitation, or let's have some visitation that is exactly parallel to whatever the court gave you at the time. So not only is it going to be a waste of your time to go to FCS mediation, but it's also going to forever and ever and ever have an FCS report in your court file that they will then refer to in the future. That if, you maybe have a mediator who isn't exactly completely diligent, or a judicial officer that's not completely diligent, they'll just flip to the back page, see, oh, FCS at the time recommended supervised visitation. And that's automatically the bar in which you're starting from. And that's not necessarily fair or appropriate, because maybe that FCS report was cut and drafted and edited and signed and filed before the DVRO actually got prosecuted. And maybe you beat the DVRO. But trying to reinvent all that work later or connect the dots of the timeline is very difficult. So with that, the other things to kind of keep in mind is that a restraining order, a temporary restraining order, if it gets continued out, obviously has a lot of impacts on your custodial situation. It has a lot of impacts on your living situation. But even more than that, you can't own firearms. So if you're some sort of professional that has to be able to grab a firearm or do some weapons training, or use your firearms to recertify in a military setting, you potentially are going to put your own career at risk, or the protected party put your career at risk by filing this. The other thing is, it comes up on background checks. So if somebody searches you and you're applying for a new place, now that you got kicked out of your old place, now it's going to come up that you have a restraining order pending against you. And so that's going to be something that now landlords are considering. These are all things that I think people don't necessarily get the benefit of understanding off the bat, because nobody has the time to break it down and explain it to them. So those are the things that I think that really impact your life and your livelihood in terms of the TRO. Now, as we venture kind of into the land of actual hearings on restraining orders, how to beat them, how to beat false allegations, or, we're very one-sided. I realize I'm very one-sided in this dialogue right now about, how to approach them if you're the restrained party. But this also goes if you're the protected party. But here's the other thing. I think there's some strategy and some school of thought out there that if you're the protected party, that you should just continue these out as long as possible, that you should just continue the temporary TRO out and, let the court set it for as far in advance as possible, and we'll go forward at that point in time. Here's the reality. As your evidence gets stale, your case gets stale, the need for, the restrained party to have lesser visits is stale. So while there might be some strategy, or might be something there to the thought of let's continue it out further, it's not always in your best interest. Sometimes your best interest is go forward as soon as the court will hear it. Because if you have the facts, if you really can substantiate a restraining order, if you really have, it on video that this person did X, Y, and Z, and then you went to the hospital and you suffered these injuries, and oh, by the way, look at all these text messages as well. If you really have that kind of evidence, use it. Mm-hmm. Go forward. And, the things that people don't realize is cops change duty stations, they retire, they do all these other things. And so let's say that during the prosecution of your restraining order, it got continued 5 times. And now you're finally at a point where you want to do an evidentiary hearing, but you can't find the cop who took the statement. And so now there's evidentiary ways to kind of overcome that, but those are the things that you need to think about. Those, if you really have the evidence, don't delay it. The other thing is there's part of the carve out in the Domestic Violence Prevention Act and the Family Code talks about how a judicial officer at their discretion could essentially say in layman's terms that, these parties have had enough time to cool off. Yeah, you guys moved out and maybe there was some domestic violence or some weird stuff that happened, but now it's been 8 months. There hasn't been any other incident. We don't need a full restraining order on this. The party number 2, they've behaved themselves. They're doing well. The visitation, it's going well. We don't need all of this. And so while I don't ever encourage people to, as the party number 2, as the restrained party, don't ever guarantee or count on that. Don't do that. But it is a possibility. And so as a protected party, you kind of want to strike when the iron is hot. You want to go forward when your evidence is there. And it also presents all these opportunities in court, in open testimony, where if there's a lot of emotion going back and forth with party number 2, as a skilled litigator, I can potentially pull that emotion out of party number 2 when I have him on cross-exam, and I'm not him or her, sorry, the distinction, but whether it's mom, dad, girlfriend, boyfriend, I can potentially take party number 2 on cross-exam and talk to them and get them into this role of their emotions because it's so fresh and they feel so wronged by this TRO and they want to talk to me about it. And at the end of it, I can make you show the judge exactly who you are. Mm-hmm. So I don't need to do that for you. But if they've had time to cool off, if they've had attorneys in their face, if they've had all these other things, if they've had all this coaching, frankly, if they've had some therapy, if they had some anger management, I might not be able to do that to them as easily. And so I advocate for go forward if you have the evidence to go forward. Go forward, put your case on, try your TRO. The other thing here is, and we'll get into DVROs now, but if you're in a trial and the court substantiates your domestic violence restraining order, if you in the future, let's say they can issue it for 2 months, they could issue it all the way up to 5 years. And let's say in the future that they issue it for a year and you come back and you say, no, we after, 3 months within that year's up, so 9 months out, you say, no. I still need the protection of the court. You can apply for an additional extension on that restraining order and on that DVRO. As long as it hasn't expired yet, you could go back and apply for one, but you can't do that to extend the permanent one. You can apply and the standard is you're subjectively scared, not objectively. Not the reasonable person in the room would be scared, but I'm still scared because they sent me 500 text messages after they put me in the hospital. I'm still scared because they chased me around the house, held me by my neck, and admitted to all of it in text message. Here you go. That subjective standard, if you don't have an underlying DVRO, then you don't get the benefit of trying to extend it. You would have to file an entire new TRO, which if you have the facts, file your new TRO. But it's much easier, much more cost effective if you have that DVRO and you prosecute a subsequent extension by way of just subjective fear. That is much easier to do than going through the whole rigmarole of a new TRO, new hearings, getting a new DVRO process, all of that. And so we can't even reach whether or not you are going to get a extension on your DVRO if you don't get the DVRO first. So go forward when you have the evidence. Go forward when you know how to subpoena the officer. Go forward on those things. Now we'll switch into DVROs and really
before we switch to DVROs, Kelly, there's this place where you and I deal with, especially in early stages, where somebody will file a TRO and it will be for weaponized purposes. They'll set it up at a time. Our clients will fall into that trap. They'll make mistakes during that period of time, which extends this process or makes it more difficult for them to back up out of. And what I want to discuss a little bit in this moment is, one, I want people to understand that those initial conditions of that filing are really important for them to get into the game, get representation, get coached up, and start the things that need to be started. And part of what I try to do, and I think you and I are in agreement with this, is regardless of what the extension or what the timeline is of that TRO, is to start building, start doing the things that are going to be reflective of, yeah, there's a problem here. If there wasn't a problem, this wouldn't be happening. I'm taking positive action in this direction. And how, better ask, what are the things that are specific that somebody shouldn't do once that happens? Once that TR comes in, you know it's been set up, you know it's BS, you know that this is a tactic to gain temporary custody, to start the alienation process, if you will, or all of that. These are some of the things that are really common in my arena, and certainly in yours as well.
So I'm glad that you asked, because I forgot to tell you. And the interesting thing is that almost any time that somebody tells me that they have a TRO against them, I don't get off the phone or I don't leave the meeting without telling them one thing, just one. If you don't hear me for anything else that I've told you, one thing: don't violate the TRO. Do not violate the TRO. Do not write to the protected party and say, party number one, this is totally bogus. This is absurd. I'm a great parent. How could you do this? Blah, blah, blah. Don't do it. Don't do it. Don't ask your family to do it. Don't ask your friends to do it. Don't ask a third party to do it. Don't ask your kid's teacher to do it. Don't do it. Don't reach out to the kid's therapist and say, hey, can you contact party number one and say X, Y, and Z? Don't do it, because there is underlying case law that says that a family court could find, so a judicial officer in family court could find that any violation of a TRO, temporary restraining order, is enough to substantiate a finding that at the very least you basically disturbed this person's peace because they felt like they were afforded the protections of a TRO, and you violating it then took those protections away from them and made them no longer feel protected. That in and of itself can be reason to grant a restraining order. Don't do it. So a DVRO. So with respect to that, I never, ever, 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 ever leave a meeting without telling a client, do not violate a temporary restraining order. You can let your lawyer handle it. You can say, hey, this is completely bogus. The other thing is, at the point that you feel like it doesn't even matter how you feel. At the point that a restraining order has been filed against you, or you feel like one is going to be filed against you, you have some homework to do. You need to pull all your text messages from the last 2 years. You need to pull all the emails. You need to make sure that you have every piece of evidence that you potentially could have that would negate claims of abuse or negate claims down the road. Now, it's possible that maybe you said some stuff in text message that's not good for you. And that's possible. We have, I've come in contact with several cases where I wish my clients didn't say that, or I wish that wasn't a fact, or I'm on the other side of it and I'm so happy they said that. But it's still something that you need to tell your attorney right away. You need to tell them. It's a full disclosure process over here. So don't ever conceal a fact from me. Don't ever lie to me about it. Don't ever, think, oh, I'll stop giving her text messages and let me see. Okay, maybe I'll give her back to December and then I'll tell her I don't have anything beyond that, because beyond that wasn't very good for me. I need to see that wasn't very good for me, because I need to know how bad is our exposure, so that when I'm evaluating your case, I know whether or not your exposure is 0 months, your exposure is 5 years. And that will help me along the way to figure out, do we settle out of this case? Do you prosecute it? Do you prove that mom's equally bad, or dad, that protected party is equally bad? It frames the strategy for how you go forward. So your first job, when you have even the inkling that a restraining order has been filed or is going to be filed, is to do your homework. Go get all your text messages. There's software you can buy that takes all the string of text messages off for between you and a certain number. It's fantastic. It keeps it all very consolidated. It's none of this, 9,000 screenshots anymore. And it is very easy to go through and easy to read and easy to see kind of the dynamic of the relationship and the parties. And that's where your defense is going to lie. That's where you're going to be able to find a lot of good evidence. But if you don't have those, if you've deleted them, if you've left your phone behind, if you've said, you know what, you can have my cell phone, if you've, allowed them the passwords to your iCloud account and they hack into your iCloud account and delete all of your history, there's a problem. So you need to go make sure immediately that you're protected. Forget the knee-jerk reaction of, this is awful. I feel betrayed. How can this happen? How could they do that? They're wrong. This is all false. Forget the victim mentality for about 5 minutes, because you need that 5 minutes to get your head on straight. You need to do your homework. You need to preserve what evidence you do have. And frankly, you need to hire a lawyer. There are a lot of things in family court that if you came to me and said, I just want to do this, I might tell you, you don't need a lawyer for that. Do this, you'll be fine. You don't have to have this. You need a lawyer every step of the way, at every turn. And if you don't have the right lawyer, you could potentially end up in a situation where your lawyer has kind of worked against you, and not intentionally. It's just you and your lawyer are not on the same plan. Or
the lawyer, and I've run across this a lot, is that attorney just does not know how to handle restraining orders.
Right.
And those initial, again, we're talking about initial conditions and really getting, ahead of the curve. What you're talking about, Kelly, and I'm just going to be real brief with this, and I want our listeners to hear this, is what Kelly's telling you to do is start your homework quick. Your attorney is really expensive if they're going to do this homework. And you know where this stuff is. You can comb through it. You can even work with a coach to help go through the stuff and highlight this stuff to get it ready. So when you give it to your attorney, he or she can grab a hold of that and say, okay, I got this. These are the key pieces. We don't have to go deep into the weeds. We got enough right here, because to your point, the courts are pretty full. And if you can be precise with the material that you're giving them, the exhibits and stuff, so they can just get the drift of where this is at in the first 2 paragraphs, you're way ahead of the game. So distilling it down is important too.
Right. The best lodgement, the best piece of evidence, the best whatever is one piece of paper that says blank, this happened, this is an admission, one text message. Listen, I don't need to read 18 pages of talking parents to get the gist that y'all don't like each other. Give me the one text message where they say, you're a dirtbag and I'm coming after you. Give me that text message. Mm-hmm. I don't need to know that you guys were talking about, exchanging all this sports equipment and it didn't pan out. And then party 1 got mad at party 2. I don't care. And the court doesn't care either. And when you're talking about you have limited time, that's so true. And you don't want an attorney that's up there fumbling and looking through all their documents and they're, I'll find it at somewhere. You don't want that. You want, it's exhibit 1, it's bait stamp 30, look it up. And so if you do have the occasion to do your homework and have all of that ahead of time ready for your attorney, it's also going to make your attorney's job on both sides. If you're getting a restraining order, and I'm going to talk briefly about why I think it's also very important to have an attorney when you're trying to get a restraining order. But also if you're defending against a restraining order, if you can just show your attorney, this is what I have, point blank period, it's cost effective for you. It's easier for your attorney to evaluate whether or not you actually have a good claim. And it makes your case just easier, more streamlined to work with. You seem organized. You're an attractive client. If you're all over the map, you might be passed over. This seems really complicated. This is, the client can't get their stuff together. They can't figure it out. I don't know if I believe them. I don't know if they have I don't know if they have a defense. I don't know, there's so many unknowns that if you're asking me to make a prediction for you, I might tell you I don't know, because I need to look at the documents. I need to see what the evidence says. Now, I want to talk just very, very briefly about something that I always tell clients, and honestly, I would tell it to anybody. I want you to picture a box right now with 4 lines. And every time that you make a statement to the police, you draw a box, you draw a line of that box. You write a declaration for your TRO, you just drew the bottom of the box. You called up your friend and it turned out your friend wasn't really your friend and she recorded the call and you made a statement that was maybe not so great to her. That's another line of the box. Every time you make a statement, whether it's in a pleading, whether it's to somebody and it gets reduced to some sort of report, child welfare services, police report, school report, whatever it is, that is now an admission. And you have now created a box at which I have to operate on the inside of. I can't all of a sudden change your story. I can't change your facts. That's the box. And so that's what we have to go with. So every time you make a statement, you're packing yourself into a tighter box. And that's not always a problem. That's not always a bad thing. If the truth is great and it's beneficial and that's actually what happened and we can even substantiate that or corroborate it with evidence, that's great. But if you are potentially making a statement and you don't know if that statement could be used against you or for you, it's very good to have an attorney who's evaluating that. For example, if you're the protected party and you say, that's when I saw so-and-so go after him, what does that mean? What does that mean? Does that mean verbally? Well, if you can argue it on both sides of the fence. If you're the attorney for the other side, you can argue they were running after him to make sure he was not running in the parking lot. You could argue they were yelling after him, hey, make sure you're okay. If you're this side, you could argue they were screaming. Of course, this kid was running from him. Of course, he was afraid. But you've now made that statement that can be argued on a pendulum either way. And the unfortunate thing is that you don't know that as a pro per writing your pleading. You don't know when you tell a story, how if you say, well, I didn't know what to do. I was scared and I ran at him. Well, that paints a picture that you're an aggressor. Were you running at him or were you running down the hallway to get away from him? But he happened to be in that same line of trajectory. And so the question really becomes, are you articulating what actually happened in the best possible way? Because people are not, as a baseline, people are not professional communicators.
Concise narrative is so important.
Right. And if you're not a professional communicator, if you don't know how words matter or words are used every day, you're going to have potentially some missteps in your initial filing of your restraining order. The thing that kills me is when people will file these restraining orders, they'll subsequently hire an attorney. The attorney then drafts all these beautiful pleadings for them. And I go back to the very initial filing and I pull out the initial declaration that was written when you were in pro per and you didn't have an attorney coaching you. And I say, well, wait a minute. This is different. We left this out from the second one. Well, of course they did, because it was a fact that their client pled in pro per that they were hoping never went noticed. And so it takes a very diligent attorney to look at defense that way, but it also is a lesson for somebody who's filing a restraining order, because there is nothing worse than somebody who actually needs a restraining order not getting one because you don't know how to articulate or communicate. And frankly, that goes for everything across the board. If let's say you had a, child abduction issue, and you went ex parte and you were pro per, and in your ex parte you say, oh, mom's withholding. Well, that didn't paint the picture of what happened. not mom's withholding. Like, there was supervised visits. You were supposed to not ever leave the state, mom snatch and grab. The court's going to deny that ex parte because you didn't tell them the full story. But if you told them this is the story, then there's more context, and then they can understand what actually is at play here. And the DVRO is the exact same way. Why is it important that the kids are included? What happened to the kids? What did the kids see? And the same goes for your defense. When you're drafting a defense, the same would go for that. You need to make sure that you're articulating what happened in the best possible way, period.
Is there a strategy or a thought process by which a parent will get a TRO? The children will be a part of that TRO, and we come into the hearing and we don't have a huge problem about the restraining order in and of itself because it gives me some distance and I like the distance, but I want to break the kids off of that.
So,
and is there a reason? And this is another question that I've got, and I think I know the answer, but I'm going to let you tell me. Is there a reason to capitulate to a TRO or to a restraining order just as a tool to keep distance?
So here's the problem with that. I would say that, I would submit to you that a lot of clients probably feel like, hey, I don't care if they have a TRO. I'm good with never seeing that person again in my life. But the problem with that is where TROs become DVROs and they have lasting impacts on your background check, on your ability to own a firearm. All those things are still coming in against you. Now, if we're talking about a TRO with kids on it, you cannot stipulate to a TRO with kids. If your facts are terrible and your attorney's telling you, you trust your attorney and your attorney's giving you good advice and they say, look, this is the bottom line and this is the best you're going to do, by all means, if you trust that attorney, you need to follow what the attorney's saying. Get a second opinion, do whatever you have to do. But what I'm trying to say is don't take my blanket statement right now as oh gosh, I can never do what my attorney said if this is what they say, because that's not how it's meant. But what people need to understand in getting a DVRO substantiated against them is that the court has now made a finding that you have perpetrated domestic violence, whether that's harassment, whether that's stalking, whether that's an actual battery or some sort of physical violence. Frankly, it doesn't matter when you boil it down because it all catches in 3044. And that's the family code that tells you that if a DVRO has been, or a finding of domestic violence has been substantiated against you, that we're going to have a lot of problems with custody. The court can't give you full physical custody. The court can't give you joint legal custody because you have this DVRO. Not a DVRO. You have this family code 3044 presumption that now applies against you. Unless and until, of course, it's only a presumption, which means you can overcome it. There are ways to do that. But unless and until you overcome that presumption, the court can't give you full custody. And so you potentially don't even qualify to have legal custody of your kid. More than likely you don't. And so if you enjoy making decisions about where your kid goes to school, who their dentist is, who their doctor is, who their therapist is, if those are decisions that are important to you, which they are to most parents, you can't have this family code 3044 presumption applied to you. Now, if you want to overcome it, there's other things we can talk about of, how do you overcome this? Of course, it is something that can be overcome, but it is very difficult to stipulate to a TRO. Now, if you got to a position where you stipulated to just a TRO to stay in place, and then, essentially it would be a stipulation where, hey, we'll continue this for 6 months. If everybody's done their best behavior between now and then, it'll get dissolved at the next hearing. And that's something that then it is just a temporary restraining order. It didn't really, impact you. There was no finding of domestic violence against you. If you were ever going to stipulate to a restraining order, an actual DVRO, the issue under that with Family Code 3044 applied against you is that you would also then at the same time want the stipulation to acknowledge that Family Code 34 either didn't apply, the presumption wasn't triggered because, let's say the facts in this case didn't trigger the presumption for Family Code 3044 to apply, or you would want, them to acknowledge that you've done something to overcome the presumption. Since the date of event, they completed 52 weeks of DVRP, domestic violence prevention recovery program, I think, domestic violence recovery program. That's what you would want your stipulation to say. But this is what I want to say, because I think you asked me this question, Brooke, because I know that a lot of what you talk about in your program and in your class is just different types of personalities, and maybe, the narcissist or the covert narcissist, or just somebody that's just toxic and you just want to be away from them. This is what I'm going to tell you. People have this misconception that as a DVRO being in play, or a TRO, that both parties are restrained from each other. And that's not true at all. If you're party number one and you're the protected party and you're out in public and you see party number two, the restrained party that just walked into a grocery store, guess who has to leave? Party number two. If you're party number one and you walk into a grocery store and party number two has a cart full of stuff and they're super busy and, they're very clearly overwhelmed and they have everything going on and they've been in there for a long time, guess who has to leave? Party number two, not you. It's not a violation if party number one walks up and starts chatting up party number two. It's not a violation for party number one. It's a violation for party number two to sit and participate. So party number two has to immediately tuck tail and go. So if you're talking about these types of personalities where you would want the distance, where you're like, absolutely get away from me, thank you, Christmas couldn't have come sooner, that's not going to help you, because these people at some point, that type of personality, they're just going to reach back out. They're just going to connect back over that bridge. And you're going to be the only person that's in violation. As the restrained party, you're the only person in violation, not the protected party. Now,
so with that piece right there, and so somebody has a restraining order, temporary or otherwise, and that person, that protected person, keeps reaching out through phone calls, through showing up at different places, is what you're telling me is that's not a grounds to get that overturned? Because they are clearly reaching out. There's not a fear, if you would, of the content?
I'm not saying it's not a grounds to get it overturned. The two are not mutually exclusive. I'm saying that while it is a fact, and that's something I was just going to say, is that essentially, is that fact that they keep showing up at the same grocery store at 4:00 that they know you're there, they keep showing up at your work, they keep calling you, are those facts that potentially, you can help discredit their claim that they're scared or that a restraining order is necessary? Yeah, absolutely. You can use those facts. However, it's not mutually exclusive with the idea that as the restrained party, that you're not still going to be in violation of the TRO. You would be or the RO, you would still be in violation of it. And so is there a defense? We're not there yet. We're just hitting the threshold of, well, hey, wait a minute. Is there some benefit here to just stipulate to, hey, a restraining order? Now, I'll say this, if the parties, if it's really that bad and the parties are, wanting to pursue essentially cross restraining orders against each other, folks, I don't think you need cross restraining orders. Just stay away from each other. Just have a mutual agreement that this doesn't need to happen. But I think what you would find is that one of those parties is going to be the person that pokes the bear. that needles the situation all the time. And so it's never truly going to be, hey, we both mutually don't want to be around each other. Because if you're dealing with somebody at that maturity level, you don't need the court intervention. You don't need all of that.
Right. But when we step into personality disorder land, which we are often
Right.
here about, we do have somebody that is intentionally trying to stir the pot, to make problems, and to get somebody in trouble, thrown in jail,
100%,
whatever it is.
100%.
Right.
Well, and
Kids
that
away,
brings
whatever
up,
it is.
right. And that brings up, the kind of the next point is a violation of a restraining order that can be prosecuted under the penal code. That's a misdemeanor. A violation of a DVRO, also prosecution under the penal code. So these are all things that potentially have very big impacts on you. It's really just not something that you would ever, unless there's absolutely no other way, or there's some other end game, like in order to get custody, you have to kind of jump through the hoops of, okay, well, I did a bad thing. I'm going to agree to a restraining order. I'm going to agree to it for a lesser amount of terms. I'm going to start working my way through the custody ladder and kind of jumping through all the hoops to show the court, like, I've overcome this issue. There's zero reason to just stipulate to we're going to do a full restraining order. You're doing yourself a disservice, because you're putting yourself in the way of criminal liability. You're putting yourself in the way of the Family Code 3044 presumption applying to you. There are just too many negative facts, and it doesn't risk benefit analysis. It doesn't outweigh the risks here. Now, with that said, it is very possible that maybe you did something that wasn't fantastic, that you're not proud of, that is going to land you a 5-year restraining order, and your attorney says, hey, let me try to make this a little less terrible for you. Let me try to fast forward through this process for you. That happens all the time. And by no means do I mean for anybody to construe this as legal advice to never, ever, 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 ever stipulate to a restraining order. Sometimes stipulating to a restraining order would be much better than your judicial officer, who's going to have your case for the next 3 years, hearing about whatever it was that you potentially did that wasn't fantastic. Now, that's not to say they won't hear about it down the road, but there's just something to be said to just always fact check every situation with your actual attorney, who you trust, who you find credible, who knows they deal with these types of things. And that kind of harps on the point that you were talking about earlier, is that you see some attorneys who pick up these restraining order cases, or maybe they don't pick them up, but they find their way into them because maybe they represented the parties in the initial bit of the litigation and it had no restraining orders involved. And now you find yourself in a land that maybe your attorney was, more geared towards mediation, or maybe your attorney was more geared towards settlement, and you've never actually seen your attorney litigate, and you can't find anything about how your attorney can litigate. That's not the attorney that you need representing you in a restraining order. You need the right tool for the job.
Always. I want to talk, while we've still got a little bit of time, about how these things are weaponized, and specifically, there are attorneys that will pop a TRO, try to make some space, and create allegations that are going to make this thing go into more high conflict. You and I had one recently where the client stipulated to a long cause hearing or a evidentiary hearing that really screwed them in that process, rather than pulling that up short. And there's a strategic piece to that from somebody that is setting that stage in that way. One is about money, the attorney really getting in and doing that, but there's also some other pieces. My question is, when a judge gets wind, okay, so we're in the early stages of a divorce or a custody battle or whatever. This has been the standard by which an attorney has set the course with. And they get to the back end of this TRO, they've had the hearing, and it's denied, and the judge is just thinking that this is a tactic, that this is something that somebody has done to create a mess. Do they come back and do anything about that? And does it leave a taste in their mouth down the road?
So that question is very, 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 very dependent on who your judicial officer is. And they always change in terms, you potentially get a new judicial officer every 3 years. But here's really the issue is there's no yes or no answer to that question because it's so heavily fact-based. So I'm going to give you kind of some examples and then we can expand on it if you think that that's helpful. But if you were to file I'm just going to call it a false restraining order. If you were to file a false restraining order and you were to be caught on that and the court says, this is absolutely bogus. Like this is the biggest ridiculous thing I've ever seen in my life. But it's written in such a way that at least passes muster for a TRO. And so you get a TRO and then maybe 6 months down the line, the court looks at your TRO and says, oh, your underlying evidence is actually a bunch of baloney. And there's a bunch of evidence where protected parties reaching out to them, talking to them. The court can do a couple of things. If you falsify abuse, the court can definitely look at that in terms of whether or not it really is in the best interest of the children to be with you. The court can also look at it and make a credibility finding against you. And those two things are going to follow you forever and ever and ever in that litigation, because the court can look at it and say, well, you told me that a door was slammed on you on this day. And I actually see a video and you were the person that was slamming the door. Or the court, you told me that you arrived for an exchange and the restrained party was irate and screaming at you. And you asked me to review the video. And I reviewed the video. And you were the one screaming. The other party wasn't. That credibility finding is going to follow you forever and ever and ever and ever. And the court is going to have this bad taste in its mouth about, essentially what your motives are in litigation and what's happening. But I will tell you, the amount of times that I look at a TRO and I can tell there's a defense or maybe things have been really exaggerated, and the amount of times that you can actually prove it, or a judicial officer will say, yeah, this is absolutely baloney, is like 1 to 10. I'll look at a lot of them and think there's a defense. This is explainable. I can see where a temporary restraining order was granted, but when we tell the full story, we're going to figure it out. It'll be fine. Put on your evidence, etc. Maybe there's some fibs here or there, nothing that rises to the level of, wow, this was just outright, completely fabricated, completely exaggeration. But the problem is that the courts don't, you don't have a lot of those Perry Mason moments where the courts see that as well. You just don't.
Yeah, the reason I asked that question, Kelly, is through the course of this and a lot of the podcasts that I do, I want to set reasonable expectations for the people as they start to go in, because they get into this, well, that's not fair, and that's not justice, and that's not this, and that's not this. This is family court. Things are oftentimes, from my standpoint, judges are shooting from the hip. They're making decisions in the moment that they don't have enough for. And we've got to go back and really do our homework. And you listeners have to do your homework and work with somebody that can help you pull all of this stuff out so your attorney can do their job. And again, Kelly was talking about full transparency, giving me all of the emails that are pertinent, not just stuff that is just a bunch of noise, and distilling it down and getting these things so you can get better outcomes. But don't
don't do this on your own. Don't think that you can navigate this particular thing on your own. The traps are too sharp and too nasty if you screw up, and it's too easy to screw up here. So make sure that you've got a good attorney. Make sure that you're working with a coach to help you pull this stuff apart if you feel that you need one. And go about this smart, because if you don't, you're not going to come out of this well. We're out of time. We've knocked the hell out of this. I think there's another time for us to do some more of this.
No worries.
There's just so much good information, Kelly. I feel like I sat in a law school lecture here for a little bit.
I'm sorry.
No. The information is really good. And Kelly said this at the beginning. If you are in this arena, come back, listen to this over and over and over again, pull the nuggets out that you need, and then move with caution and move with intention as you go through this.
100%.
Kelly, thank you. Yeah. Thank you for joining us here. Again, really valuable information. Everybody take care, and we'll get something out to you next week again. Take care.
Thank you so much.
Brooke, people don't have to wait until Friday mornings to get more content. If this is something that's helpful for them, right? This isn't the first time you've broadcast anything or recorded anything or put anything out there in the world. What are the other ways people can get the help more aggressively or speed up their recovery process? What materials are available for people right now?
Well, I've written a book called The Black Hole of High Conflict, and it's available on Amazon and Kindle.
Great.
And everything that we're talking about is really compressed and put into there. So this is a really good starter place to get in and get your mind working and to see what these concepts are about and how to start to apply them. The other place that I think that is valuable is to go to our website and look at some of the blog articles that I've written. Those are available there as well. They go into some of these other arenas, and that's at www.highconflict.net. So the book, the website are also really good places to get the material. And also we have classes. We have high conflict diversion program classes that you can get into and get some one-on-one help with this as well.
And you know me, I'm aggressive. Whatever I want to become good at or learn, I find someone who's good at it and pay them and hire them and shorten my learning curve. What if somebody just wants your help? Somebody says, Brook has this information. He's good at something I'm not good at yet, and I want to work with him. Do you have any type of coaching or consultations or anything like that?
Absolutely. I do one-on-one coaching for custody cases. I help people get ready for family court services. If you've got that in your community, I work with attorneys and clients to help them with managing and strategically setting them up to have more successful cases as well.
And how do they reach out? You want them to just go to the website or email or phone, or what's the best way for them to reach out, raise their hand, and say, I need some help?
They can email me. My direct email is brook@highconflict.net. That's BROOK at highconflict, HIGH, conflict.net.
Perfect. That's everything everybody would need to get some help, right?
Absolutely.
Thank you, Brooke.